All right. Happy Saturday, everybody. I believe it's Saturday. I am Melissa Mays. We are running a little behind today, like we usually do. So can't really say that's much different. Unfortunately, this is a show about some things not changing, but other things changing. So just want to make sure everybody can hear me and, see the bit of sarcasm that's going to be full today. So, so we're running a bit behind, but it's Saturday afternoon. The whole goal of this show is to put out the information and discuss with everyone what's going on in Flint. And the reason we do this is so that way Flint residents can be kept up to date on what's going on in their community, but also so the rest of the world can know as well, like the facts that are happening with Flint, in Flint, by Flint residents. But also, we're seeing more and more and more about how Flint is being replicated, the Flint water disaster and the dismissal of people and the suspension of democracy and all that great stuff is happening across the board, unfortunately. So we are going to move ahead and hopefully folks can catch up. If you're watching this, please share and, feel free to ask questions. We do check back in after the show. And of course, most of you know how to message me. Hit me up on my personal page, or you can reach out to me at What Are You Fighting For? My name is Melissa Mays. I am a Flint resident and also founder of What Are You Fighting For? And I'm also operations manager at Flint Rising, which is a coalition of Flint groups on the ground fighting for justice and, beyond clean water in the city of Flint. We founded What Are You Fighting For as a portal of accurate information for Flint residents, but also for the world to see what's actually happening in Flint. And now we are, What Are You Fighting For and Flint Rising has expanded out. We're working with other communities like Three Rivers and, Newark, Jackson, Mississippi, basically across the United States, because we know that Flint's not the only community that has been suffering with toxic air, water, soil, lack of housing, lack of resources, loss of democracy, all of that, great, wonderful stuff that's happening across the board. So that being said, today is day, 3,613, if I am correct, which it hurts if I am, in the ongoing Flint water crisis and counting. And the reason that it is counting is because profit is put above people constantly, and more work is put into silencing the residents of Flint and avoiding responsibility than actually fixing the problem. The solution in Flint is quite simple: replace all the pipes, starting from the water treatment plant, the distribution mains in the streets, the service lines that go from the street to the home, as well as interior plumbing that the decisions by the state government and then of course the city's choices recently to let things just rot instead of fixing them. But the choices that government made to switch the water, to not treat the water, especially the state government, since we were under state control at that time, and it ate up, basically, it corroded all of our infrastructure, and we are still getting served up water, which now this current administration felt the need to experiment on our water even further and start blending two different water sources so we can pay two different water bills wrapped into one very expensive one. And basically so we can support the bad investments that were made to build a unnecessary, more privatized pipeline so, corporations could benefit instead of, the residents that are footing the bill for this. Anyhow, decisions were made, obviously, to switch to a more corrosive source, to not treat the water, and our infrastructure got destroyed, our bodies, our health, everything. So, oh, goodness. Spam already. It's too early for this. And I say this even though it's in the afternoon, but Melissa didn't get much sleep. So going from there, the laws are outdated, right? Our federal and state laws are outdated when it comes to protecting water. The Safe Drinking Water Act, the Lead and Copper Rule, we have made incredible, work forward progress. Currently, the state of Michigan, thanks to the work Flint residents and everything that Flint has gone through, the state of Michigan has the strongest Safe Drinking Water Act on the books. We got that passed in 2018. And then we're working on a federal level to also make sure that the Safe Drinking Water Act and Lead and Copper Rule are updated to protect people, because that's what these laws are supposed to be for, is to protect people. Unfortunately, health gets left behind in that. So that being said, we filed, the residents of Flint we worked hard starting in late 2015. And we filed in January of 2016 a Safe Drinking Water Act case in federal court. And it's not for money. It's not for any of that. None of the, this is not a damages lawsuit. This is so not to be confused with the ongoing class action or individual damages lawsuits, but it was an enforcement lawsuit, basically to force the city and state to come into compliance with the Safe Drinking Water Act, since Flint was in violation of those laws due to the high levels of lead and also other contaminants, the disinfection byproducts and everything. But because our laws are so outdated, many almost as old as me, we could basically only grab onto the lead and fight for that. But that was something, because when a city goes into a violation of the Lead and Copper Rule and the Safe Drinking Water Act, one of the remedies, the main remedy, is to replace the lead lines, right? Similar to taking out gas out of paint or lead out of gas and paint, you want to take the lead pipes out of the ground so people stop, consuming and cooking with, and even bathing in contaminated water, especially contaminated with lead, because it's so well known the damages of heavy metals, neurotoxin. It disrupts so many of your systems at any age, so not just the young or the elderly who are particularly vulnerable, but at any age there's no safe level of lead. And not to cook with, not to not to have as ice cubes or put in your coffee, none of that. So here we are, and we were in violation when basically the state of Michigan took control over the city of Flint, and then a couple years later switched our water to the Flint River, and chaos ensued, and then people died. It's the severity it continues to get downplayed, but here we are, and then people are suffering these long-term health impacts that seem to have been a mystery to the world until now. So, which it's not. I say that with all the sarcasm in the world. I just last weekend was with the Society of Toxicologists, and it's well known, all the links to things like ADHD and autism and compromised immune systems with heavy metals, especially lead, is very well known in the medical community, in the scientific community, but we're still drinking out of lead laden pipes. So that being said, we partnered with the ACLU of Michigan, who brought in the NRDC, or Natural Resources Defense Council, to sue on behalf of Flint residents, everybody who's impacted by the water. And we had to choose named plaintiffs, so at least one impacted resident. So we chose myself because I had a lot of evidence at that time. But also I live in Flint, and this was a case that was basically forcing the city and state to come into compliance moving forward from the date that we filed, right? Based on past harms. But again, nothing that's based on an individual or any of it, things like that. It's just the way that these federal cases are set up. And then the Concerned Pastors for Social Action, because the federal law requires that there also be a group that anyone could join with no fees, no membership fees, no anything, that could represent the entire city, the entire impacted, group of people. So basically anybody can walk into a church and not have to pay membership fees and, whatever to be a member. So that was a great way. We already had the Concerned Pastors for Social Action working on other types of issues, but they actually fit the bill to be able to say, okay, look, this can represent the entire, even if you don't go to church, you could walk into a church and say, I'm a member for free. And that's the way the law is set up. So that's why you'll see like Concerned Pastors for Social Action and Melissa Mays suing the state of Michigan, City of Flint, and then the EPA was involved as well. So again, we filed, and we sent the notice over to file September of 2015. We filed in January of 2016, and then in March 28th of 2017, we settled all parties, so city, state, and plaintiffs, so residents of Flint, everybody. We settled in court, which was forcing the city to replace all the lead and galvanized steel service lines. The state was to pay for it. We were supposed to, and still do, are provided free tap filter cartridges, pitcher filter cartridges, and filter replacements up to 1 year past the last pipe being replaced, which it still hasn't. And the same with free lead and copper tests 2 every 6 months until 1 year after the last service line is replaced. There was also other things like enforcing the EPA's emergency order that no water switch or water source changes could happen without proper testing. And because that obviously was not done previously and a lot of damage was done. But also that they had to comply with reporting and restoration, all of these things. We came to agreement, keeping at that time the water pods or points of distribution sites open until like lead levels had fallen. And we fought for all these things, the community outreach and education program, or CORE. There was a lot of things that we fought for and were able to get. And the biggest thing being the pipes getting replaced, because therein lies the problem, right? As long as the pipes are in the ground, it's going to be contaminating whatever water is sent to us. And right now, there's a question mark about the quality of our water because of the blending. But that being said, even if it was the most perfect water, these contaminated pipes would still be contaminating, the corrosion within the pipes and the rupturing mains. The unstable water system is still going to be contaminating our water. Now, because the laws are outdated, it does not cover interior plumbing or the distribution mains. But then interior plumbing, that was something we fought for with the civil cases, the damages cases, the class action cases. And then with the distribution mains, that we were supposed to be fighting for federal money. And we're still waiting to see why, if with all this infrastructure bill coming out that Flint residents helped create for the rest of the country and get for the rest of the country, why hasn't our administration focused on getting the money for our distribution mains? Or why are ARPA funds, the American Rescue Plan Act funds, being provided to residents for new water heaters, help with these really expensive water bills, or replacing these mains? Why is it going to cover cleaning up, one of General Motors' old sites that was contaminated? Why do we have to pay for that? Well, I didn't make that mess. I didn't switch my water either. So there's a question as to what's going on with this city administration. And here we roll into this. So over the years, there were delays. At first, when we settled and we started the program in 2017, there was a learning curve, right? We had, under the Weaver administration, we all came together with this plan. There were, multiple different areas, zones that were being bid out, lots of different contractors, subcontractors, everybody working on this to get these pipes out as safely as possible and thorough as possible and get the properties restored. That includes your yard, driveway, street, and sidewalks, making sure that it's restored to where it was, before any construction was done, right? To make sure it's safe and to make sure the pipe replacement was done properly, as well as the water testing and monitoring and everything to watch to make sure that the lead levels were dropping as pipes were coming out. And they were for a bit. So from 2017 to end of 2019, there were over 27,000 holes that were dug out of about 31,000. So we were making pretty good progress, even with the hiccups and everything and the learning curve, because we were the first city to have ever done this and to win and to do this in such a short amount of time. And we were on track to be getting done in 2020. So that was the agreement. The settlement agreement was that, 3 years to get the pipes out. The city would do the work and hire the contractors. They would bid out and everything. And then they would make sure the work was done and then invoice the state. And the state had agreed to pay $97 million for the work that had been done. So again, they didn't just hand the city over a pot or a blank check. Everything had checks and balances. And we had gone back to court over several things. The state wanting to get rid of core early, wanting to close the pods early. So we fought and went back and forth, delays. And then I guess the state had brought in AECOM to manage the program, and that was a mess. So then we had gone back and forth to get, AECOM on the right track. So it's been a long, very tough babysitting job, unpaid, for myself and several others. And the attorneys, they got attorneys' fees. They got a portion. I think it was when in 2017, we settled, they had provided receipts for $2.4 million in attorney's fees, and they were awarded $895,000. So a percentage of that the state had to pay the attorneys for attorney's fees, expert fees, things like that. Myself and the pastors got nothing, even though we missed work and had to pay for parking and all that great stuff, whatever. But it didn't matter. We were moving forward and there was progress. So, here we come back to multiple times in 2020. Obviously COVID hit, the pandemic hit. So we agreed to a 6-month pause until everybody could figure out what's going on and safety. And then everything was supposed to pick back up because you could still do the work in the yards and the streets without going inside people's homes. But then also, that being said, the city of Flint started sending out notices saying, if you don't let, the plumbers or contractors in your house to change your water meter during COVID, you would get your water shut off. So, we couldn't understand why the pipes couldn't be replaced, because they would just come in to flush the water, but also to check at the meter to make sure that you didn't have a partial service line replacement. But they could come in and replace your meter, and that was okay, but not to do the service line work or the restoration, which didn't require any kind of going inside the house. So everything was stopped in 2020. And of course, it kind of coincides with, at the end of 2019, us getting in, Sheldon Neely mayor won the mayor's seat. And so then he went from state rep to our mayor, and then everything kind of hit like a grinding halt. And then in 2021, there was no work done whatsoever. While we're sitting here going, what's going on? What's going on? We had a hearing at the end of 2020 because the city wasn't even testing properly. They hadn't been doing the testing, the proper lead and copper rule testing, so that we were in violation there. And we were used to the state of Michigan actually beating up pretty hard on the city, kind of fighting back and forth. And then that stopped. So we're not sure why the state, who also is, by the way, a party to this lawsuit, why they stopped pushing back on the city and getting the work done, but they did. It's just what happened. We're not sure, but here we go. So then 2021, nothing's going on. We can't get answers. 2022, then the city's like, okay, so we go back to court and we keep doing these stipulations. Multiple times we've gone back and saying, okay, if you need more time, you have to tell us. You have to present a plan telling us how you're going to get done. What's your deadline? When are you going to get finished? Trying to be patient and understanding with, the world being turned upside down, but also what's going on, because we just want the work done and done right. So then we go back to court, file another stipulation. The city promises to have the work done by a certain time, fails. 2022 comes around. The city promises the same stuff. We go back and forth with court. The court approves the stipulations. The city sets a new deadline, misses it again. And so so then we're just sitting here pulling our hair out. What do we do? Right? They're just continuing to blow this off. So we had a meeting asking, where's the teeth? And this was March of 2023. Oh my goodness, it feels like it was so recent, and it was not. So March of 2023, and a resident asked, where's the teeth in this? Well, again, this is not a criminal case, and there's only so much that can be done. It's not a damages or a money case. They're supposed, and this was a settlement agreement. That's the thing. It wasn't like the court just had ordered all of this to be done. We all came to the table in 2017 and agreed. And even if you switch administrations, you're still supposed to get the work done. That's the thing. You're supposed to continue ahead with the work, but it doesn't seem to be what's happened. So in May, there were deadlines, and that were missed again in March and May of 2023. And then we went to court in June to hear what's going on, because the city was again in violation. And I don't know if you can hear it, but there's some beautiful music happening. It's my clock. Anyway, reminded me that I was late, but that's fine. Nothing's new there. So like I said, some things don't change. So we went ahead and talked about it, and filed a motion to the court because the judge in February of 2023 had put out an order giving specific deadlines and specific orders for the city to do, and they blew past all of those. They did not do what they were told. And so we're like, okay, we have to hold the city in contempt of court, a federal court. So we have to request that the judge do so. And with that comes fines, fees, including attorney's fees. And while those are, in our mind, just not the greatest of solutions, because obviously the city's not managing their money properly. Again, that unfortunately there was a surplus like at the end of 2019, and here we are back. Although money's going out to all these companies and groups from the ARPA funds instead of actually helping our city get better. Okay, skipping that. So, we kind of drug our feet on filing because we're like, well, we're hitting them with money. But then we thought about it and we're like, okay, if we file, maybe just the filing will get the city to do the work. Once again, didn't happen. So that was back in, right around May, June, July. Last year. So then here we are. It's this past Wednesday, I believe. March 12th, the federal judge issued his decision and held the city of Flint in contempt of federal court and contempt of his orders. So I'm going to go ahead and we're going to get all exciting up into this and we're going to explain what this means. Now, I'm going to put links in, because you know how I do. I make sure everybody has all the evidence they need and they can go back on it. Make sure that everybody understands, and you can take time, you can pause, you can go back through this on your own. You can ask questions of the attorneys. Because some of the press put out was kind of funny. They just put out defending the city kind of thing, saying, well, we did this. And it's not even talking about what happened with the contempt case or with the contempt filing. But so I just put in the chat a link to the NRDC's statement. And then I'm going to put right now the ACLU's statement up, which the ACLU and NRDC are our attorneys representing Flint. And basically it says a federal court held the city of Flint in contempt for violating a February 2023 federal court order requiring the city to reach certain milestones in its lead pipe replacement program. And the city of Flint had originally agreed to replace all the old lead pipes by early 2020, but it still has not completed the work. In addition, there remain almost 2,000 homes where residents have been living with damaged properties, some for years, caused by the pipe replacement. So basically the work had been done to excavate, to check the service line and to replace it if it's lead or galvanized steel, and nobody came back to fix it. So basically the judge said the city has failed to abide by the court's orders in several respects, and it has no good reason for the failures. Judge David Lawson wrote for the court. The city is in civil contempt of the court's orders. And it says the plaintiffs in the case filed the motion to contempt last May in the lead contaminated water crisis, Flint water crisis, and it was the plaintiffs did not ask to recoup their attorney's fees and costs in connection with bringing this contempt motion. Nonetheless, the judge found that it was appropriate to reimburse the plaintiffs because, again, when we settled in 2017, the amount that was provided, $895,000. That was it. Our attorneys have asked for nothing since then. However, we've had to continue to go back to court. We've had to hire experts. We've had to spend a lot of money on data research and going back and forth, being in court multiple times and holding, this is just the city in violation, not even the state, back and forth. And the attorneys have come out of pocket and have paid nothing since 2017. And, I will quote Judge Levy, who is the judge over the civil cases, where she says that she does not want the attorneys to go, basically bankrupt. She wants them to have some kind of payment. So they'll, other attorneys will be encouraged to take on difficult cases such as these. And not basically lose everything to do so. So basically we have time to think about it, and I'll go over that more. And so here's my quote. The court's decision to hold the city of Flint in contempt reflects the depths of disgust and despair felt by the Flint residents. We've only gotten this far because residents refuse to stop fighting for Flint. And it says, in order to see any real progress, Flint residents and our allies have had to prod the administration every step of the way. We should not continue to suffer because of the city's failure to meet the judge's orders and their own deadlines. And that's important because the city has set these deadlines and failed to follow through with them. And then Pastor Overton wrote, we've waited almost 10 years for the water crisis nightmare to come to an end. While we are encouraged by Judge Lawson's ruling, the true outcome we're seeking is for the city of Flint to succeed in finishing the lead pipe replacement program, including by finishing the overdue work of repairing damage to residents' properties caused by the lead service line replacements. Court intervention has been the only way to hold the city to its promises, unfortunately. And then one of our attorneys, the amazing Addie Rolnick, had at the NRDC had said residents are not asking the city of Flint to do the impossible. They simply want officials to meet deadlines and finish the work the city has already agreed to. Beyond the homes that still may require lead pipe replacement, the city needs to finish restoring these residential properties that have been damaged by the replacement work. We'll continue to hold officials accountable until this work is fully done. And I just want to say, and Bonsitu Kataba, who is also one of our attorneys with the ACLU of Michigan, she says, we applaud the court for holding the city accountable for the obligations they agreed to nearly 7 years ago to bring clean, safe drinking water back to the city of Flint, to ensure the residents' lead pipes are replaced and that their properties are restored. This work still needs to be completed, and we will continue to monitor the city's compliance to ensure that those lead pipes are replaced and the residential properties are restored. And again, I just want to say, without the attorneys, without the ACLU of Michigan, without the NRDC continuing to listen to us, believe us, stand up with us, as the Flint residents are saying, my house hasn't been done, we wouldn't be where we are now. So I cannot thank them enough. So now going on to the fun stuff. And I'm saying fun stuff for me because I'm a nerd, but also because this is coming from the judge's own words. So here is actually the filing. And I highlighted some areas, so we're going to delve into this, but basically so people can understand what's going on here, because I read through a lot of the media and the statements and the city saying there's only 30 lines to replace yet. And there's this, but first of all, I'm going to say, I don't believe that. That's my personal statement, because I know more than 30 people that are saying they're still waiting. We have a list of people that have turned in consent forms repeatedly, and they have not been reached out to. I have a stack sitting on my desk that I've sent in, we faxed in, emailed in, so we're gonna have to do it again, apparently. Fine. So what we're talking about is this is what the judge issued. This was on March 12th, so this past Wednesday. It says the settlement agreement brought to a conclusion, or so it was thought at the time, a lawsuit that was filed under the Clean Water Act to redress the well-documented and widely publicized contamination of the city's water system. The settlement agreement established deadlines for various phases of the replacement and restoration operation. These benchmarks included outreach, reporting, and inspection requirement deadlines intended to ensure the Flint residents were notified of their rights to remediation and permit the plaintiffs to monitor the city's progress in remediating the defective water distribution system. Now, for the sixth time in 6 years, the plaintiffs seek to enforce the settlement agreement as modified by several. And this is, again, we've had to go in violation, and we've modified the original agreement to give the city extra time, to give them the time that they've asked for, to, the deadlines that they set. So we had to go back to court. We had to work it out amongst ourselves, and then we had to go back to court so the judge would agree to it. Here we go. Several deadline extensions that the court has granted following the parties' stipulations. The plaintiffs allege that the city continues to miss deadlines for completing promised replacement work, including by failing to complete by March 1st of 2023, the outreach to all the homes eligible for service line replacement, and to determine by May 1st, 2023, the addresses where the city still needed to complete restoration work, and 3, to provide accurate and complete monthly restoration reports to the plaintiffs. So that was what we were requesting, and that's what the judge ordered in February of 2023. So some of the things that the city's talking about in their rebuttals and in their statements is kind of silly, because it's not even what this order was covering. And actually they admit that there's work that still needs to be done outside of this contempt motion. So, okay, great. So basically, the court held a hearing on the motion June 30th of 2023, during which the parties presented evidence. The court also permitted the parties to file supplemental briefs in August and November of 2023. Based on the evidence, it is apparent that the city has failed to abide by the court's orders in several aspects and that it has no good reason for its failures. So again, we have heard, Mayor Neely, we've heard, the city attorney, everybody, in the administration coming out with all of these excuses. We've heard about, staffing shortages, this and that and whatever. All of these things were presented during court, that, the city attorneys were presenting these excuses during court and in the media, and the judge has said 100%. Based on the evidence, it is apparent that the city has failed to abide by the court's orders in several aspects, and there is no good reason for its failures. And again, looking back, there's plenty of time. The city of Flint has had plenty of time to offer up evidence to real reasons why it could not meet these expanded deadlines and all these different stipulations. The city has demonstrated belated compliance since the hearing, but even now, it has not actually replaced all of the lead service lines, which it originally promised to have replaced by March 28th of 2020. The city is in civil contempt of the court's order. So just want to make that clear. We agreed to this. That was the date, was 2020, and it is almost, 4 years past that due date. So I just want to point out 4 years. 4 years. And it was supposed to be done in 3 years. And the bulk was done by the end of 2019. Again, over 27,000 holes dug at the end of 2019. There was only, 4,000 left. Yeah. So I highlighted a lot of stuff. I may or may not read through all of this, but this will be up so everybody can read it. It's readily available. Make sure that everybody's got it in their hands. And NRDC and ACLU have been great at posting the filings as well. And that's where I got and downloaded it. So it says the agreement is extensive and the parties and the court repeatedly have modified it to ensure the city's compliance and to protect the health and safety of Flint residents. At the end of the day, that is number one. That is the main focus, is to make sure that the Flint residents who had no say, no blame in the city and state failing to protect us, and the state switching our water, EPA not catching it and not fixing it, all of the levels of government that have failed us and letting us come to harm, the fix, to come into compliance with the Clean Water Act and Safe Drinking Water Act to make sure our water is no longer harming us. The efforts by the city and state have failed. And again, the state's sitting by letting the city fail, not pushing or prodding them like they had previously. So again, they're also a party to this, and they're just sitting back letting this happen. Even though before, like, they were in control of the city and managed every movement, that actually led to the water switch and the cover up. But here we are. So the health and safety of Flint residents has always been on the forefront of Judge Lawson's orders as well, because that's why we're here. The agreement required that the city implement a plan to replace all lead and galvanized steel service lines at Flint residences. It required the city to conduct outreach to residents to seek their consent to excavate their service lines. The agreement also mandated that the city address property damage caused by the service line work to the residents' sidewalks, curbs, and driveways. The city must repair any damage by filling in the excavation trench, removing debris, ensuring uniform plant cover, and repairing any broken asphalt or concrete. So it's laid out in 2017 very clearly what restoration means. Somehow that got lost in the mix as well by the city. And it says, finally, the city must make monthly status reports to the plaintiffs detailing outreach and restoration efforts, and it must maintain sufficient records to comply with all reporting requirements. Okay, very easy. I mean, honestly, the 2017 settlement agreement isn't even that long, but it's very clear of what needs to be done because it's not that complicated. Now, why this is in red is because usually the judge's strong words and his decisions we put here. The city has not fulfilled its obligations under the agreement as modified, even though we've heard, Mayor Neely and, the city attorney come out saying, oh, no, we've satisfied the settlement agreement. No, the judge doesn't agree. The city has not fulfilled its obligations under the agreement as modified. And that's with, again, the modifications are the extended deadlines to help them out. So they didn't even meet that. As of the filing date of the plaintiff's motion, the city has yet to complete outreach, excavations, or restoration. It has made inconsistent reports to the plaintiffs, and it has repeatedly missed deadlines. The city's violations have caused difficulties and, in some cases, hardship to Flint residents, many of whom have waited years for excavation and repairs. And we had several Flint residents actually put in their declarations and explain how this has made their life even harder, which we're the victims and should be protected, not made, life made more difficult for us. So then this goes through and and again, you can read through this. It's referencing, other court orders. I have this in orange because I want to make this clear to everyone. Many also still do not have access to safe tap water because the city has yet to replace all water service lines. Residents are still advised by the Environmental Protection Agency and the state of Michigan not to drink any tap water unless a special filter has been installed, one that actually removes lead. And since we have main breaks all the time because of our unstable infrastructure, because apparently the city thinks that if you just, leave a pipe alone and ignore it, it'll heal itself. We have a lot of main breaks and unstable infrastructure. The water will need to be filtered and then boiled for safety's sake. So again, even though we've heard from Mayor Neely at community meetings that filters are for convenience or comfort, no, that's not true. The judge added this into his decision that all residents of Flint, they're not to drink their tap water unless it has had a special filter installed. So please, please, please be safe. So violation of the judge's orders. The plaintiffs have filed 5 previous motions to enforce the agreement and to remedy the city's mismanagement of the service line program. So then it says the court granted the most recent motion to enforce February 24th of 2023 with the remedies. The remedies were, first, the court ordered the city to create detailed written service line plan describing the steps the city would take to complete the work. Seriously, come on, to complete the replacement work, to just give us a plan. Then this was to be done. That all this work was to be done by August 1st, 2023. And we've heard, the mayor come out and say that he believes that they satisfied the agreement by the August 1st deadline. No, otherwise we wouldn't be here, right? Then the court directed that the city include a plan for completing outreach as quickly as practicably and no later than March 1st of 2023. That did not happen. Second, the court ordered the city to compile and provide the plaintiffs an Excel spreadsheet. Simple. No later than May 1st, all of the previously excavated addresses on the 2022 replacement eligible homes list and indicating whether the city has they have decent contemporaneous documentation that has completed the restoration and the date of the restoration, or whether a completed visual inspection has verified. And here's the list of, in detail, what restoration means. No asphalt, concrete, or other debris remains. The address has a complete uniform sidewalk with no gaps, holes, and the sidewalk is uniform on both grade and alignment. The address has complete uniform driveway with no gaps or holes, and the driveway is uniform in both grade and alignment. The address has a complete uniform curb with no gaps or missing pieces, and the curb has uniform grade and alignment. The lawn is free of holes and trenches and is of uniform grade with no visible depressions. If any visible topsoil on the greenbelt or lawn is free of debris in the greenbelt, or lawn has consistent uniform cover. And the water shutoff valve is flush with the surface of the lawn and does not propose a tripping hazard. This was from our original agreement, and it's just common sense. These are all things to make sure there's no more safety hazards. So I read that, and it's ridiculous. It's simple. You dug a hole, fix yard, driveway, sidewalk, street. Make sure the water shutoff is not sticking up, and just fix it. It's not that hard. So third, the court directed the city to make monthly reports to the plaintiffs in an Excel spreadsheet. Again, not hard. Of the excavated properties where the city's completed and documented restoration. So we want to know what homes had been excavated, what homes had their lines replaced, what homes had restoration done, which ones had been inspected, and which ones still needed restoration. Basically, this says we couldn't get it. And basically, it said the plaintiffs can now contend that the city has violated all 3 terms of the court's February 2023 order. So then we go into detail about outreach. in April 20. And so here's details, basically saying that there were 1,369 homes that still needed to provide consent to replacement. The city did not complete outreach to these 1,369 homes by September 30th, as promised. So again, the city has also failed to meet this deadline. It's in red. And it's for outreach. It says the plaintiffs moved again to enforce the settlement agreement the city stipulated in response to the March 2023 deadline, saying that they will complete outreach. They did not. And then here's some data that you can read through showing the information that we were given. And the fact we had hired data scientists to go through this and testify was something else. And here's more details talking about one of the data analysts, Noah Attell, who had to be brought in to look at the data and found homes missing. Basically, he found homes that were on the excavation list and not the restoration list. So they were excavated, but never made it over to the need to be restored list. But then there were homes on the restoration list that they needed to be restored or had been restored, but were never excavated. So yeah, that was a headache. And then basically, we sit there and talk about, like, this is what's going on. Who's at fault? The city points fingers at everybody else. Restoration. The city acknowledges, actually, that it did not meet the May 1st, 2023 deadline for determining the scope of the remaining restoration work. Still waiting on a plan here. Although the city has been conducting visual inspections in the fall of 2022, it acknowledges it didn't do them right. And they had to go back. The city agreed that it would have to redo at least 2,000 non-compliant visual inspections, meaning that short little block of paragraph I read earlier. Yeah, they weren't done right. May 18th, 2023, the city also informed the plaintiffs that it had decided to complete visual inspections at 11,000 additional addresses, for which it only had hard copy records of the possible restorations. No evidence, no proof. Again, that was a shocker. But plaintiffs' counsel, that's us, their counsel states in a declaration that based on our analysis of spreadsheets, the city reported 5,452 addresses where it had completed visual inspections as of May 1st, 2023. 21,138 addresses were completed or had completed or still need to complete visual inspections, and between May 2nd and May 10th, and 26,590 addresses were to complete or still need to complete visual inspections as of May 10th. So the numbers were all over the place. Nothing made sense. Oh my goodness. Sitting in court was mind-blowing and breaking. So skipping through, talking about the data scientists, again, you can all read this. It's public filing. Just skip ahead all of that. And again, I call myself a nerd. These are super smart, extra powerful nerds with the data. Again, that's the one thing with us is we bring the evidence, right? So the plaintiffs blame the city's mismanagement on its contractors for its mismanagement of the restoration work. The city told the plaintiffs that it had no staff working on restoration reporting. That was stunning. But instead relies entirely on its contractor, Rowe, which it had hired in April of 2022. Again, two years after, like 2 years after it was supposed to be done, to oversee the service line exploration, replacement, and property restoration. However, the city did not inform Rowe of all of its reporting requirements, and Rowe only learned of all the relevant reporting obligations in March of 2023 when the plaintiffs, us, we explained to Rowe what needed to be done. So we didn't hire Rowe, the city did. So just want to, and then here's the testimony from Rowe stating that they weren't given the information by the city who hired them and who pays them. And so here's going through the dates and the confusion and the reporting mess that we weren't getting. So in this, we had filed to hold the city of Flint, or to request that the judge hold the city of Flint in contempt, as well, the city administration, as well as Mayor Neely, because Mayor Neely had been out there saying that the work was done, and that was not true. So basically we did not name him as a defendant in the initial settlement because the city at that time was under the governance of the state emergency manager when we filed our original complaint. However, the mayor's authority since has been restored, and the mayor once again serves as the chief executive officer of the city of Flint. Now, why did I underline that? Because the mayor likes to say that it's everybody else's fault. It's his staff. He didn't know. False. The judge even says here that the mayor is basically the CEO of the city, and he is in charge. So just want to point that out. And it says, as such, he is responsible for taking care of the laws taking care that the laws should be enforced, including by making recommendations to the city council and submitting an annual budget. And he is also responsible for appointing the city administrator and other executive staff. So that's under him, and that's under the city charter. So again, as much as it seems that the mayor wants to point fingers at everybody else, he is ultimately in charge because we're no longer on emergency management, even though I feel like the goal is to put us right back there. Now, he also serves as a chief spokesperson for the city of Flint, including its service line efforts. And he's also said things saying that things were, done and blah, 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 blah. However, he's also said that he's committed to continue the work and that in the Scripps interview, he had taken the blame. So that covers some of that here too. But the thing is that at the end of the day, the judge did not find the mayor in contempt, but he found the entire city administration in contempt, but says the mayor is in charge and has a responsibility to, make sure his administration gets the work done. Because, you're the boss, you're the mayor. So there you go. So the contempt finding, the plaintiffs request that the court impose sanctions to remedy the city's ongoing violations of the agreement as modified by the court's February 24th, 2023 enforcement order. They argue that they have satisfied their burden of proof, which we had to prove that the city didn't do it and, didn't show the will to get it done. By demonstrating that the city had failed to comply with clearly ordered outreach, restoration, and reporting requirements, and that they contend that the city cannot show categorically in detail in its inability to comply with the agreement because the cities repeatedly took actions at odds with the agreement and did so despite the plaintiffs repeatedly informing the city of its outstanding obligations. Again, this is an ongoing, constant communication between us, our attorneys, residents of Flint, and the city. We have meetings with them. We have status updates, all this stuff, and we tell them when they're going off track, when they're not supplying us. We give them warnings. So the last thing you want to do is drag everybody back to court. But here we are. The city responds that civil contempt is not warranted because it is not meant to be punitive and should merely coerce future compliance. Such coercion is unnecessary where compliance has been achieved, they insist. However, sorry, that hurts my brain. They maintain that the amount is indicative of, so basically they're saying that they had completed like 26,000 visual inspections, and they argue that 582 addresses they concede require inspection represent just over 2% of the totals. So they're saying that we're still not done, but it's only 2%. Doesn't matter. That doesn't matter. But they say the city maintains that this amount is not indicative of neglect, and the state of the inspections at these addresses are complete as of July 7th. Now they're saying that they're done. Finally, they argue that they have taken all reasonable efforts to comply with the court's orders. Their argument on this point offers few specifics. Rather, they list the work completed and so far and its cost. That's their evidence. That doesn't even answer. And again, you can tell by some of their statements in the media, they're not even answering to the actual judge's order that they're being held in contempt for. So again, headache. They're like, well, okay, the judge is saying we're contempt for running this person over, but we planted flowers over here. I mean, that might be a ridiculous analogy, but you get what I'm saying. It's not answering to the actual orders. So in red here, underlined in red, one thing is certain. The city did not comply with the latest court order that detailed the remaining procedures and extended deadlines for compliance. There is another certainty. The power of courts to punish for contempts is necessary and an integral part of the independence of the judiciary. And it is absolutely essential to the performance of the duties imposed on them by law, because the city was trying to say it wasn't the judge's place to hold them in contempt. And they wanted just to be coerced to have it done. However, we've tried that already, going back to court all these different times. And we were hoping that just the filing of it would get them to straighten up. Didn't happen. A litigant may be held in contempt if his adversary shows by clear and convincing evidence that he violated a definite and specific order of the court requiring him to perform or refrain from performing a particular act or acts with the knowledge of the court's order. To meet this production of burden, the circuit's defendant must show categorically in detail why he or she is unable to comply with the court's order. So the judge wanted to see why the city didn't comply. Like, what is the actual reason? And the judge notes that a good faith effort is insufficient. It can't be like, well, we tried, we just didn't. Okay, there has to be actual reasons, because this is grown-up land. This is adult land. You can't just say, well, I tried and that's good enough, right? It is not. Rather, the contemptor must show that it took all reasonable steps within its power to comply. And it says, contempt is reserved for those who fully understand the meaning of a court order and yet choose to ignore its mandate. So, with that being said, describing what contempt is and how you can qualify to be in contempt of a judge's orders, as described above, there is ample evidence that the city's conduct fits that reservation. It is undisputed that the city missed the court-ordered deadlines for completing outreach to service line replacement eligible homes and for assessing the scope of its remaining restoration work. There is clear and convincing evidence that the city violated definite and specific provisions of the agreement and the February 24th, 2023 order. It's clear. Okay, the judge said it's very clear. So then he goes into more detail. The judge says the city effectively suggests that the plaintiff's motion should be denied at most because it has completed the ordered outreach and restoration assessments. However, and that's what they're saying in the media. No, we did this, sort of. However, the mere fact that a party may have taken steps towards achieving the compliance is not a defense to a contempt charge. Despite remaining questions about whether the city has completed all the required outreach, it now appears the city has complied with many of the items raised in the plaintiff's contempt motion. Nevertheless, the city may still be found in contempt for its earlier violations. But the courts regularly find parties in civil contempt even when they have complied with the court order after the initiation of the contempt proceedings. So why do we have to continue to go back to court? Why do we got to do this? Why? So here's what the judge has decided. Because the plaintiffs have met their burden of proof, the burden shifts to the city to demonstrate that it was unable to comply with the court's order. So we proved that the city was in contempt by violating the judge's orders and ignoring them. And so then they have to say, well, we did violate them, but this is why. Here's the evidence that, that was preventing us from doing the work. The judge just found that the city has not made that showing with regard to its outreach, restoration, or reporting obligations. It has not even attempted to demonstrate that it took all reasonable steps within its power to comply with the court's February 24th, 2023 order. That's huge. There's no attempts, let alone that it made any effort to marshal resources, assert authority, or demand the results needed to comply. To the contrary, the city acknowledges that it made significant efforts to comply with the order only after the deadlines had passed. So again, let's put it this way. If you pay your mortgage late, you have a due date, you pay your payment late, you're going to be assessed a late charge, right? I mean, that's what happens. That's a penalty. And that penalty is there to, say, hey, next time don't pay late. Now, again, I'm not supporting banks and all that great stuff, but that's something that we can all understand, right? Calling up and saying, hey, yeah, so I paid my payment 15, 20 days late, that should be fine, right? No, it's not. And that's where we're at. And it's that level of immature, except this is far more serious because people's livelihoods, lives, and health depend upon it, right? So then the judge goes into tearing apart the city's basically two principal justifications for the delay: winter weather and preparedness for the door hanger. And he said these two justifications on the city's behalf are unpersuasive. First, winter weather cannot explain the city's failure to perform outreach to homes eligible for service line replacement by March 1st of 2023. Although Mr. Markstrom from Rowe Engineering testified about the difficulties conducting compliant visual inspections and restorations of work during the winter weather, the city provided no evidence that the winter weather actually inhibited outreach activities. And the city conducted at least some outreach in December of 2022, suggesting that it was possible to do so in all seasons. The city has failed to meet its burden of showing that it took all reasonable steps to comply. The city provided no evidence about snow cover in Flint during the relevant months. And because we're talking about going to May and everything, right? And when site inspections did begin, Mr. Markstrom testified that Rowe did not increase its staffing until May 1st after the court's deadline. Had city officials been ready to proceed at that capacity in early March, the city would have sufficient time to comply with the court's May 1st deadline. The city knew how many properties required visual inspections, and it knew how much time it had to complete the inspections, yet it failed to show why these could not be completed by May 1st. So the judge is just fed up, right? I mean, it just seems like that to me. So, I mean, I know I'm fed up. I'm sure you all are fed up. We're tired. And then it said, finally, the city attempts to contextualize its belated compliance, listing its achievements thus far. Again, if you've cut somebody's leg off, you can't be like, well, yeah, we cut their leg off, but look over here, we gave them some Snoopy stickers to cheer them up. The city undoubtedly completed much of what the settlement agreement has required. Okay, yeah, with all these extra years as well. But that does not excuse the missed deadlines. If the court's deadlines were unfeasible, the proper path would have been for the city to seek a modification. The city never did that. The city could have just asked for more time. They did not. Instead, deadlines came and went with little note. The defendants did not ultimately complete their required task until after the court's June 2023 hearing. So again, they did the work after they got in trouble. So going back to what the judge says and talking about other court references, other, court decision references here. Here is undisputed that the city repeatedly ignored the court's orders and acted only after contempt proceedings were threatened. That is why we did this. That's why we wanted to hold the city in contempt, not because we had nothing else to do or because we were bored, because something had to be done to get them to do the work. We thought threatening them with contempt motion, that might be it. And then it actually talks about other case history where it says in Glover v. Johnson, the Court of Appeals cited approvingly in a district court's finding of contempt where public officials allowed deadlines to pass without advance announcement, volunteered explanations, awaiting complaints by the plaintiffs before even treating the court treating the court with concerning delinquency. So basically they waited until we took them back to court before they did anything. And they displayed an evident sense of non-urgency, bordering on indifference, contrasting vividly with the spurt of activity on the heels of the plaintiff's motion to filing a contempt. So basically, they did not care, did not show an interest to care until bam, we went to court and proved that, they're not doing all this stuff. Then perhaps they figured they should pick it up. Why do we have to do that? Why? It's unnecessary, especially going back to the original, agreement, settlement agreement in 2017, where everybody was on the same page. Let's get this work done. There's urgency. But then, when you switch administrations, I guess not everybody has those same, priorities, like getting the lead out or affordable water or taking care of Flint residents' public health and safety and education and all that. So again, careful who you vote for. That being said, the same findings are evident in this present case, and the city again appears to have made genuine efforts towards compliance only when the plaintiffs spurred it on by filing their sixth motion to enforce under the agreement. The city did not take all reasonable steps within its power to comply with the court's order. The city has not met its burden of showing an inability to comply. I mean, they could do it, they just didn't. To comply with the court's orders. The city is in contempt of the court's clear and unambiguous February 24th, 2023 order. So there we are. So again, as noted above, the court has the authority to order sanctions for contempts even after a party has complied with the court's order, but the plaintiff's November 2023 filing indicated that the city has still not complied with all of the requirements of the settlement agreement. The plaintiff's sought after remediation remedies are not moot. So basically saying what the things we're asking for are not ridiculous. They're very important still. A court may impose coercive or compensatory sanctions as a civil contempt remedy. So it's saying what can be done and that what we're asking for is important. So to get to the end of all this, if you stayed awake and stayed through this, congratulations, you're doing great. This has me sharing my life with you and the things that we've been doing since 2015 with this is just, again, this is not the damages lawsuit, this is not the money lawsuit, this is just the compliance and pipe replacement and property restoration lawsuit. So the plaintiffs have not asked for compensatory attorney's fees for any specific amount. So if you see reporting with an amount in it, wrong. They need to knock it off. The amount of the award must be reasonable and generally measured as by the lodestar method. So this is talking about, and if you hear the city complaining that, that the NRDC and ACLU are going after money and they're broke and blah, 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 we still have the ability to decide, the attorneys do and the team does, if this should be done. Should they, as the judges open the door to for the attorneys to ask for fees? So basically, we've had to hire over the since 2019 or 2020, since this lawsuit has gone past its due date, the attorneys have had to pay for a lot of expert testimony, flying experts in to testify, but also the work that needed to be done, the research that needed to be done, getting, them coming out here, the attorneys coming out here repeatedly and talking to residents, filing, declarations from residents, all that stuff, things that shouldn't be done because we should have been done in 2020. But the judge is saying, okay, well, they're found in contempt. So going back to, the 2023 order where we requested this, the attorneys can request legal fees and expenses. So their fees, again, nothing for myself or the concerned pastors because we're not attorneys. Kind of feel like it, but we're not. So I'm okay with that. Especially seeing the stress that our attorneys here have gone through. So and the work, because they've not given up on us, even though we were supposed to be done 4 years ago. So again, there's cases they should be taking on and helping other poison cities and protecting, human rights and the planet, but they're working on a 4-year late service line replacement program here in Flint, and we should be leading the way and should have been done. The shining example of how to get these things done, but here we still are. So basically the method is saying that, and this is how, and this is why, like, I don't want anybody running around being like, oh, the attorneys are just going to throw a big old thing out there. No, the method that they're allowed to, if they decide to go for attorney's fees, the method calls for multiplying the number of hours reasonably expanded on the litigation, so the extra work that they put in, multiplied by a reasonable hourly rate. And then it says the court will permit the plaintiffs to submit their request for reasonable attorney's fees incurred in seeking the enforcement of the February 24th, 2023 order. So it's not going back to the beginning, because I think I saw some articles that had listed that was absurd, and people just making estimates and guesses. And so then the question is why should the attorneys get paid? Why should there be any money coming out of the city? We don't want that. We never wanted that. We did not want the city to pay anything. And that's why at the beginning of the settlement agreement, we went to court. We fought to have the state pay. And me personally, I believe that the state should pay for this as well, because they've sat back on their heels and not done anything to push the city forward. Like not with reasonable, not like they did at the beginning when they were really up on the city's backs. But, the city needs to work that out, because we can't let this go. If we let it go without any kind of punishment, this will not stop. This will never get done. And shortcuts will continue to be. So there has to be a punishment, right? There has to be, as the resident had asked us in our March of 2023 meeting, where's the teeth? There has to be teeth. And of course, these aren't criminal cases, so they're hard to find. And did we want to do this? No. Do we still want to be doing this? No. I'm tired, man. The attorneys are tired. We're all tired. I'm tired of saying pipe replacement. We shouldn't be doing it. We should be helping other communities get theirs done, not wait for ours to be done 4 years overdue and with no real reason. Again, the judge outlines there's no good reason. The city has provided no excuses, no reasons that would justify them being 4 years late. Now, in conclusion, it says nearly 7 years after invoking this, entering the settlement agreement, it appears that the city has still not completed the service line replacement program. The evidence presented at the hearing demonstrated that the city had outstanding outreach, restoration assessment, and reporting obligations well after the deadline imposed by the court's February 24, 2023 order. The city has not complied with the court's order. It has not met the burden of showing an inability to comply. Accordingly, it is ordered that the plaintiff's motion for contempt is granted in part, and it is further ordered and adjudged that the City of Flint is found in civil contempt of the court's February 24th, 2023 order. How embarrassing, right? Like, seriously. And then you can see this. It is further ordered that a remedy for the city's contempt, so basically, I guess, punishment, because this is parenting, the plaintiffs may recover their attorney's fees, costs, and expenses, including expert witness expenses incurred in bringing the motion to contempt and the ensuing proceedings. It is further ordered that the plaintiffs may apply for this, the award of expenses, by filing an appropriate motion with the proper documentation of fees, costs, and expenses on or before April 1st. So again, it's not just a random number picked out of the sky. They have to provide, receipts for the money that the attorneys have spent, the time they've spent, the experts, the cost, all of that. And again, not myself and not the pastor. So I don't want to hear somebody out there being like, oh, Melissa Mays and the pastor's got money. If I did, my house would be fixed. My pipes would be fixed. But also, I'm not an attorney. I already have enough, student loan debt. I don't have time to go back to law school. I work 2 jobs anyways. So that being said, the biggest part here is that we had to go to court to enforce this for the 6th time, the settlement agreement that we all came into in 2017 that should have been done in March of 2020. We are almost 4 years past that date, and there's still work to be done. So when you hear the city come out there saying, oh, but we're done with this and this and this, also, where's the proof? Because a repeated problem with this is reporting. So we need proof for that. We can't take their word for it. Obviously, that's been going on and on. So at the end of the day, we will remind you all that if you have not had your service line replaced, if you have not had your property restored, please, 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 please reach out to Rowe Engineering, the City of Flint. I'm going to put this in the comments, okay? There are phone numbers and emails. Let's see. All right. If your service line has not been inspected, excavated, replaced, or properly restored, please call the City of Flint /Rowe Engineering at 810-410-1133 and or email gettheleadout@cityofflint.com and copy the attorneys at the Natural Resource Defense Council at flintpiperemoval@gmail.com. Please do this. Please, please, please. Because now they're saying there's 30 homes and this, and that, and whatever. Man, come on. So, we don't want anybody left out, because what will happen is once the settlement is finally finished, because of the laws and because it's important to get lead and galvanized steel out for, public health and your health and neighbors' health and everything, it's going to fall on the ratepayers. We have to, you'll have to pay for it. And right now the state's paying for it. So let's make sure that it gets done. And then also in the comments, if you have not given consent, you can go to cityofflint.com /get-the-lead-out, and you can complete the consent form. Or when you call or email, you can have it filled out. Actually, when Lakeshore comes, the and their subcontractors, so you can give them permission. So please, 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 get this done. Please, let's get the pipes out. Again, we've been going back and forth in court to make sure that everybody is safe and the work gets done and the residents of Flint get what they deserve with getting at least the lead and galvanized steel pipes out. We're still waiting for the money. Nobody's in jail. There's all of that. But this right here is about the pipe replacement. Also, our lawsuit does provide that you can get your filter and cartridge replacements and water test bottles for lead and copper. The Flint Public Health Navigators, you can call them at 810-410-2020 to get it delivered, or you can go to City Hall during business hours to pick them up. So check to see what hours they're open that day, and to pick up your free filter and cartridge replacements, as well as your free lead and copper test bottles. You can get 2 free every 6 months. So every season, because every time the weather changes, our water quality changes. Now, that being said, I know this was a lot. I'm sure your heads are melted. My brain's melted. But this is what we've been going through. So just wanted to update everyone on this. And if you have any questions, please let me know. But again, please, 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 if you've not had the work done, if you've not had your service line inspected, replaced, or if you're not sure, and if your property is not restored properly, please get a hold of the City of Flint and Rowe Engineering and our attorneys to make sure, so we can make sure that this gets done. Because it's from the work of Flint residents and people speaking out that we were able to get the declarations, we were able to get the information, photos, all of this to present to the judge to show him that no matter what the city is saying, it's still not done. So that being said, I'm going to close out today's episode by saying you all are amazing. Thank you guys so much for sticking with me. Late or not, long, lengthy, reading through court documents with you. It means a lot to me that you guys care and want to be informed, that you want to stick through this, because nothing is more amazing than Flint residents. And I just want to thank you all for being here. And yeah, I just am proud of being from Flint. I am proud of the work that everybody is doing. And thank you all, and just have a safe, wonderful rest of your weekend. And I'll be back soon. And until then, I'm Melissa Mays, and this has been In Flint.